Hi everyone. In this audio, we are going to cover the chapter Arbitration and Conciliation Act 1996. This act generally got into force on 22nd August 1996. So, what does this act generally talks about? It is like an alternate dispute resolution. For some of the problems of for some of the disputes arising between two parties, generally they are we are like we will be going to the court, but the court cannot solve each and every dispute. They then these alternate dispute resolutions have coming to the place. So arbitration is one of the method of such ADR. ADR is nothing but alternate dispute resolution. So in this act, the concepts we are going to cover in exam point of view are regarding arbitration. Only 4 concepts we are going to cover, and those 4 concepts shall be elaborated as per their requirement. And other than this arbitration, we are also going to see conciliation in this act, as the name itself specifies arbitration and conciliation. So what does this conciliation mean? Arbitration and conciliation both are the methods of alternate dispute resolution, but there is a slight difference between arbitration and conciliation. So first let's get into arbitration. So what are the concepts we are going to cover in this arbitration? 4 concepts. First one is arbitration, how does it work and everything. Second one is arbitration agreement. Third one is arbitrator or arbitral tribunal. Fourth one is arbitral award. Now you can see the charts I have posted here, where you can see the summary of all the concepts and everything. Here in the charts I haven't described, I haven't detailed everything, because this is like a summary chart. Once you go through the chapter completely and deeply, the concepts will be concepts will be locked in your brain. So when you see this chart, by seeing the word arbitration agreement, you have to remember what are the concepts covered under arbitration agreement. So I have named the concepts which are covered under arbitration agreement. By seeing the side headings, you have to recall the concept for the side heading. So coming into arbitration, the first concept we are going to cover, there are again regarding arbitration we are going to discuss about 3 points. What are those 3 points? Basic features, process of arbitration, and how arbitration works in India. So what are the basic features of arbitration? So generally, first let's discuss another part like ADR, alternate dispute resolution. What are the advantages and disadvantages? This I haven't listed in the chart, because this is just for basic idea. So let's discuss what are the advantages and disadvantages of alternate methods of dispute resolution. The advantages will be like, see, if it is in the court, then it cannot be as per our flexibility. So the flexibility is the advantage part of such ADR, and also lower cost of resolution, as it is not related to court and it is like an alternate dispute. If you are charging the same cost for as the court is charging, then how people will come to you? So that's why this alternate dispute resolutions who are dealing with these areas will be charging less. And confidentiality, as it is a court and it is open to public, the dispute may be open to the public over there, but here as this is individual thing, it will be confidential. And greatly likelihood of settlement also, because here these parties are having some cooperative nature to resolve the dispute, and the arbitrator will come into effect in between these two people, and he will try to settle the issue. And some cases, like in the court, there will be we will be seeing some cases which will be pending for long time. But in this case, as this is individual thing, and as this does not contain those many cases case laws and sections as in the court, there may be higher chances of getting settlement easily. And the choice of forum, here the arbitration itself has the major advantage as party autonomy, and they have the option to choose the forum also. Next, what are the disadvantages? See, every option will have its own advantages and its own disadvantages. And one of the disadvantage for this ADR is the cooperative behavior of both parties, because here the the parties are the one who had dispute in between them, then how would they come to be cooperative to appoint an arbitrator and to and because it is not like act, or it's not like government or anything. So here the cooperative nature of two people is very much important, and which will be lacking in most of the cases. So this might be the disadvantage of this ADR. And the another disadvantage is difficulty in enforcement of final outcome, as this is not like judicial proceedings. Even though they say like arbitral award is equal to judicial proceeding, still it will not have the same effect. That's why there is some difficulty in enforcement of such final outcome also, which was decided as arbitral award by the arbitrator. So these are the like 2-3 advantages and disadvantages of ADR. Now let's get into the topic arbitration. Arbitration. What are the basic features of first we will discuss about the basic features of arbitration. What are the basic features of arbitration? First to arbitration to start, there should be an arbitration agreement. What does the arbitration agreement should specify? It should specify the interest of the parties to arbitrate their dispute, and it should clearly note like none of the parties will go outside this arbitration to resolve the dispute. Like they should not go to the court after getting decided that they will arbitrate the dispute. So this is the first arbitration agreement. Next, arbitrator. Arbitrator is nothing but the person who was appointed to resolve the dispute, and arbitrator will often refer to as arbitral tribunal also, and he is like a similar to court's judge. And here arbitrator must be unbiased, and he should be independent, and he should act neutrally to resolve the dispute. Next, this is to arbitrator. First arbitration agreement, next arbitrator, next seat of arbitration. What does this seat of arbitration mean? It is a legal system. So it is a legal system. Like if it is the case of two different nationality people are having dispute and arbitrator is involved, then they have to decide which according to which law this dispute shall be resolved. So this is now known as seat of arbitration. Like which law on which law basis the dispute shall be resolved. Next, party autonomy and procedure. As I have said earlier, this arbitration, this ADRs will have an advantage, unique advantage, where the parties are free to choose everything, like free to choose which law in which law they can resolve the dispute, free to choose the place and everything, method and everything. They are free to choose applicable law and also everything. So these people have enormous flexibility in this area. Next, coming to the another feature, it's finality of outcome. What is this finality of outcome? Is nothing but arbitral award. Generally, this arbitral award is not appealable, but there are some cases where it can be appealed. Like when it is invalid arbitration agreement, the agreement itself is invalid, or he have used unfair procedure for resolving the dispute, and there is some doubt regarding the independence and the arbitrator was impartial. In these three cases, we can appeal to the tribunal. Next, another feature is confidentiality, where the dispute and the matters and the documents and everything between the two parties shall be kept confidential by the arbitrator. It should not be leaked to any other person. Next, arbitral award. It is a decision by the arbitrator. Enforcement of arbitral award. Generally, they say as you are choosing the arbitration, they have to accept like they are like the award is binding on the parties. So it should be enforced in the same manner as a court's judgment. Next, coming into this process of arbitration. What is the process of arbitration? Process of arbitration is the party 1 and party 2. What they will do, they will appoint the arbitral tribunal. Arbitral tribunal, after analyzing and after taking the inputs from both of the parties, he will give the arbitral award. Then nothing but the like judgment. This is like simple view of such arbitration process. Next, coming into arbitration in India, generally we have 3 different authorities: judicial authority, courts, and Supreme Court or High Court. Generally, judicial authority includes courts, special tribunals, quasi-judicial authorities and everything. And courts for international commercial arbitration, high court shall be referred, and other arbitration, district court and high court shall be referred. When there is a Supreme Court in place, Supreme Court will be taking care of internal commercial arbitration. High Court will be taking care of domestic arbitrations. This is regarding arbitration. Next, coming into the second concept, arbitration agreement. So, what does this arbitration agreement consist of? So, first let's discuss the meaning of arbitration agreement. Arbitration agreement is like a contract which consists of the consent of both the parties that they were going to submit their dispute to arbitration. Okay, so this is like a contract. Next, this arbitration agreement records that in the event of dispute, parties instead of taking the matter to the court shall submit to arbitration. This is just the meaning and overview of what is arbitration agreement. Now, how many types of arbitration agreements are there? Generally, there are two types. One is arbitration clause, where the clause of arbitration is included in the principal contract itself, and the second one is submission agreement, where the parties decided to arbitrate the dispute after the dispute has arisen. Like after the dispute has arisen, they will write an agreement which is known as submission agreement, in which it was written like, let's submit our dispute to arbitration, let's arbitrate the dispute. This usually happens when there is no clause in the initial contract. Okay, so these are the types of arbitration agreements. Next, what are the general principles of arbitration agreement? What are the general principles? Means arbitration agreement, as it is a contract, it should fulfill the requirements of a valid Indian contract. Second thing, consent. Parties have to clearly consent to the arbitration. Like the arbitration agreement should clearly specify that both the parties have decided to arbitrate the dispute. It should be very clear. Next, ouster of jurisdiction. What does this mean? Like once the parties have decided to arbitrate the dispute, neither of the parties shall go out of the shall not go to the court, which is instead of going to the arbitrator. Next, doctrine of separability. This doctrine of separability is, even if the principal contract goes invalid, arbitration agreement, because of its nature of doctrine of separability, it shall not be considered as invalid and it shall survive. But if the principal contract ends in a normal way, then the arbitration agreement itself also ends. This is the legal fiction. Another principle is competence to rule on its jurisdiction. Like this, arbitral tribunal has a capacity to rule on its own jurisdiction, even if it involves a question of validity of the main contract. So it can run a rule on its own jurisdiction. So these are the general principles of arbitration agreement. Very easy to remember, nothing much. First, it is a contract, it has to fulfill the requirements of contract, and it should have a consent. The consent should be clear. And ouster of jurisdiction, after getting decided to arbitrate the dispute, neither of the parties shall go out unilaterally shall not unilaterally proceed to the court to litigate their matter. Doctrine of separability, even if the principal contract goes invalid, the arbitration agreement shall not be considered as invalid and it shall survive due to its nature of doctrine of separability. Next, competence to rule on its own jurisdiction. Next, coming into the second concept of arbitration agreement, which is, it's not second, it's actually fourth, because first is meaning, second is types, third is general principles, fourth is requirements of valid arbitration agreement. What are the requirements of arbitration agreement? First, it should be in writing. Second, it should have clarity of consent. Next, it should have defined legal relationship, because as the two parties who are having the dispute, their relationship, their initial contract should be legal. If it is illegal, like a case of crime or a case of bribe and everything, the contract itself is illegal, so they can't arbitrate their dispute in that contract. So the contract or the legal relationship between both the parties should be legal. Next, final and binding the award. As the parties have decided to arbitrate the dispute, they have to agree that the award shall be binding on them. Next, specific words. Just mere use of arbitration and arbitration agreement, it shall not it shall it would not make it an arbitration agreement. So just the agreement is used. The agreement, if the agreement have just the words of arbitration agreement, it shall not be considered as arbitration agreement. Next, dispute. For the arbitration agreement to get valid, there should be a present or future dispute. Next, arbitrability. There are some cases which are not arbitrable because court still considers some cases within its border, because there will be some sensitive cases which cannot be given outside of the court. So the dispute which was referred to arbitrator shall be arbitrable first of all. Then it can be considered as arbitration agreement. Next, coming to the signature. Last requirement is signature. Obviously, the arbitration agreement shall be signed because it's a contract. Next, the fifth concept in arbitration agreement is arbitration agreement through reference. What does this mean? Generally, the two parties have already considered this arbitration clause in their previous contract itself. So, in the second contract, even in the second contract also, they are willing to refer their willing to arbitrate the disputes if they arise. So they can, instead of including the clause of arbitration in this second contract, they can just refer to the first contract, like as the terms and conditions terms and conditions will be as per so and so contract. But here the condition is the clause or the agreement in the contract to which they have referred shall clearly mention that they have decided to arbitrate the dispute. It shall not be vague. Then this can be considered as arbitration agreement. Next, coming to the last concept of arbitration agreement, when the arbitration agreement shall be terminated. There are 4 cases for such termination. First, mutual consent of the parties. Both of the parties have decided to just terminate their agreement. Second, termination of principal contract. If it is terminated in a normal way, then arbitration agreement shall be terminated. If it is terminated because of its invalid nature, then arbitration agreement shall survive. Next, death of the parties. Generally, in India, due to death of the parties, arbitration agreement shall not be terminated and it shall be continued by the legal representative. But it is if there are no legal representatives and anyone, then it shall be terminated. This is one of the reason for such termination. And fourth, due to operation of law, because some law has come into their effect and they have asked this dispute shall not be arbitrated, and they asked to terminate the arbitration agreement, then it will be terminated. So these are the 4 cases of termination of arbitral agreement. Now we have completed the second concept of the chapter, which is arbitration agreement. Coming to the third concept, arbitral tribunal. In this we will be discussing, first of all, meaning. Next, who can act as an arbitrator. Next, appointment of arbitrator and its procedure. Next, number of arbitrators. Next, requirements of arbitral tribunal. Next, duties and liabilities of the arbitrator.